Only the good die young. Only the good die young.
Counsel? Who's the counsel who said that they intentionally did not attach emails because they thought that the open court statements were? Who's the attorney that told you that? Well, I'm gonna have them right here as rules of professional conduct, see if they're gonna make that representation here in open court. Because you understand, when I asked the open-ended question, nobody answered, so nobody was even addressing that part of the issue. There's two different issues. Okay, the first thing, violation of the rules of professional conduct by trying to reach out to my law clerk is one issue. And after you already did it to my JEA and did, and I say you, it's your client through its counsel, right? And there were specific representations after it was done on the 26th of ex parte, violation of the rules of professional conduct, violation of so many different other rules, that there was going to be specific oversight and insurance that it would not happen again. It happened again. It's the Friday afternoon special. Same person, same firm, trying to then go to my law clerk instead of my JEA does not rectify the issue. The fact that somebody had to insert my law clerk's name and email address, right, into that document means it was an intentional act. It wasn't somebody using an old email, okay, because you couldn't have done it in the first place. Separate and apart from that, the court did ask an open-ended question at the beginning, is if anything was properly submitted to the court. So who is the attorney who told you that they had that understanding? Because I'm going to ask them, they're going to be at the sanction hearing, presumably under oath, answering that question. Okay, that's what they'll be. That's what's going to happen. They're going to have to be under oath, answer that question, and say on what basis and what they reviewed, etc. Mr. Tomasik, are you the one that said that?
Yes, Your Honor, and if I can...
Did you relay to Mr. Waite that you felt that there was open statements in court, and so therefore you did not need to attach email authorizations? That affirmative statement was just made to this court. Did you say that to Mr. Waite?
No, I did not say...
Okay, that's where we're done. I'm not going to keep on putting you on, okay? You understand that I'm having two different positions from two different counsel, so you can appreciate, you can have a fair opportunity at a hearing to address all of these, okay? At a sanction hearing. So I now have to go back to the first question about whether or not the court can hear it, because you all still, even the fact that you got turned around your OST because of trying to see for your client's sake, right? So they're not, because right now they're on a verdict form. They have to be on a verdict form. Are they aware of that? They have no witnesses, no anything, and it's going to closing arguments, right? And they're on a verdict form. Does the conduct of counsel. So can the court even hear the motion for good faith, because you chose not even to file your, did you file your NEO before end of day? The end of business day, the end of,
6:23 p.m.
at the end of the business day, it's supposed to be filed right before 5 o'clock. I'm not sure why people waited 2+ hours, y'all don't care about in your OST here.
But I don't have an explanation, I can just represent it was filed at 6:20.
I understand that, that's why the court asked before the end of business, right, which is 5 p.m., which is supposed to happen.
There was, if I may, Your Honor, there was just issues with my staff accessing the account. I had to...
Throughout the country, no one in your whole firm could get a notice of entry. Did you reach out to the two other firms you have? How many attorneys do you have on this case? Over a dozen, right? Did you reach out to anybody else? Did you reach out to anybody else within your own firm?
Yes.
You're saying no one in your whole firm. Ms. Rojas couldn't do it? As Pro Hoc VJ counsel?
She did not. I reached out to 2 of my staff, and I had to...
Wait, Ms. Rojas, do you have no resources throughout the country? Did you reach out to anyone at Lewis and Roca to ask them to do it?
I did not.
And how about Mr. Bobo's firm?
I did not.
Is there any good cause why? Did they tell you not to talk to them or something? Folks, it's a notice of entry of order. On something you wanted to have heard today. You understand this is very concerning. The court is really, I'm not saying a lot of the concerns and a lot of the different rule violations, right? Because I'm trying to give you all an opportunity to get this taken care of. I'm trying to give an opportunity, but you understand how incredulous it comes to a court when I hear a statement that, I don't remember how many attorneys do you have in this case? It was over a dozen with all the
18, I think someone said 18.
18 attorneys from how many different firms with cross-country, with how many total attorneys in each of those firms? And no one could get a timely, either a proper OST, a timely OST. And the reason why you got the OST on files because presumably some of the counsel here called you all, or emailed you, or notified you in some manner. I know that because one of the firms actually filed a non-opposition, which is how it even came to this court's attention, that anyone was trying to file an OST. And that was very nice of them to have done that. But you understand, and then no one from 18 different attorneys, from gosh knows how many hundreds of attorneys throughout the country, no one could file an NEO. So I have to go back to the question, counsel, can I do it today?
I believe you can, Your Honor, unless there is opposition to it being heard today.
The challenge here is if I don't hear it today, right, and your client has to be on the verdict form, the client has waived all rights to have any witnesses, right? And that presents a very, very large challenge that, in fairness, your client shouldn't be put in. So I am going to hear it, and I'll take the issue if someone brings it up afterwards. Because in fairness to your client, they should not be prejudiced by the fact that,
Thank you, Your Honor.
okay, so I'm going to hear it, and I'm also hearing it because because otherwise I have a jury waiting outside, I have substantive matters, and you're talking about a very large case that your client should not be impacted by this conduct, so. Unless anybody's telling me that the client directed you all not to file things correctly, or anyone.
The client did
I'm
not-
not asking about confidential attorney-client communications. I'm taking the benefit of the doubt that this was counsel error, not anything to do with the client. Is that a correct assumption for the
That's a
court?
correct assumption.
Mr. Thomas, is that a correct assumption?
Yes, Your Honor.
Because realistically, the client shouldn't be impacted, so I'm going to hear the motion for good faith. Okay, so procedurally, Mr. Odou, I need to hear, since I understand you're not objecting even though you filed your non-op before they even filed their motion, is that correct?
Yes, Your Honor, that is correct. Joel Odou for Will Water.
Thank you. Counsels for plaintiff, I understand that you're not objecting based on some statements.
No, Your Honor, we support good faith motion, although that's the law we say.
Okay, the court has the benefit with regards to the present good faith motion is that previously was submitted to the court in camera the amount. So the court was able to do the analysis. Feel free to go forward with whatever you wish to go forward under the applicable standards under the NRS factors, MGM factors, et cetera. Go ahead, please, if you wish to counsel.
Thank you, Your Honor. Dan Waite on behalf of defendant EPP 1. Your Honor, recognizing that there is a jury waiting and that there is no opposition, I will rest on the brief itself and answer any questions that Your Honor has.
Okay. Double checking my thing. Okay, there being no opposition, the court having a full opportunity to evaluate NRS 17.245, the appropriate standards set forth in the motion, appropriate case law set forth in the motion, which provides a variety of different factors the court can consider. That would be under. Can you vote further, please? That would be wonderful. Thank you so very much. Including Doctors Company versus Vincent, 120 Nevada 644, and Ray MGM Hotel Fire Litigation 570 F sub, etc. And Velasco Chemicals versus Davidson, 107 NEP 356 from 1991. All those factors have been met, the court taking into account any additional discretionary factors that it can do. Which, knowing where the status of this case is, knowing the various claims and issues that have presented, the court can also take that into account based on the statute, the case law, and the additional factors the court can take into account. The court finds that there's good cause to grant the motion for good faith, and also because it's unopposed, which that addresses the contribution and indemnification aspects as well. The court finds there's good cause to grant the motion for good faith settlement. It is so ordered. That is granted. I would assume you're going to get that order in very quickly to the court with
Yes,
the
Your
proper NEO to the proper location. Okay.
We will.
With regards to the sanction hearing, the court has to set a sanction hearing. Is anyone going to contend that if I sign the order on a good faith settlement, that somehow that would relieve the court of its jurisdiction on any sanction hearing? I do not want to have to hold up an order if no one's going to raise that issue. If no one's going to raise that issue, and that's waived, although, of course, the court does have supplemental jurisdiction. I'm not taking a position, I'm just asking if someone's going to contend such, and I have to take that into account.
For
The timing, the setting of the sanction here is really where I'm going, right?
EDP will not raise that argument or issue, Your Honor, to the extent it exists with it.
Okay. So when do you want a sanction hearing?
Question, Your Honor.
An opportunity to be heard.
Are there particular attorneys that you would like to be present? For example, the scheduling of may dictate if you want Ms. Rojas, Mr. Boho to be here.
The court's not going to tell you because the court doesn't know who directed the conduct, right? I only know the conduct that occurred. I don't know who directed the conduct. I don't know who oversaw the conduct. I know names that are listed on at least the most recent one, right? But it's not just these two, right? There's a whole different issues. So I have to rely on the fact that you all will provide who you deem is appropriate to provide, because remember, I keep asking open-ended questions and nobody seems to have answers or even know what's going on when the court had to ask the question in regards to the ex parte contact right on the 26th. With regard to the most recent issue. Now, I'm familiar because this one, the court could look at because it wasn't ex parte, because including all the parties, it was completely improper trying to go around the court and administrative orders to send something directly to a law clerk, particularly since there was representations which are a matter of record in this case that those things would not happen again, and that all staff would be informed of the propriety to do so. But unfortunately, it appears, well, we know what happened, right? And no one, when they received it, including the attorneys that are listed on there, which is multiple attorneys from different firms, never seemed to send any kind of communication that this was improper to stop those communications from continuing. So there's a lot of names on here of people that were familiar with it because they're CC'd, right? But no one took any action to do anything, so I don't know why, or what, I would be a wonderful opportunity to be heard. That's the only way the court can find out, right? So there's a lot of names on the CC that nobody chose to say, this is not proper, we need to follow the administrative order from a variety of different firms. And that presents its own challenge, but realistically, you all know who was overseeing it, you know who did it, you know who authorized it, you know who knew about it. This court only knows what happened, and so that's the reason we need to flush it out.
Sure.
This is not an isolated instance. Can I at least finish my sentence, please? As you understand, this is not an isolated instance. The court's trying to substantively get the client taken care of, right, with regards to, and the trial to be able to move forward, because now the jury's unfortunately had to wait out there like 25 minutes, and there's still some other matters that they may need administratively, including doing the verdict form, and that has taken trial time, as have all of these other issues, right? They've multiplied the proceedings, they've taken time away, they've caused the jury to be out there. These aren't just little oopses, okay, right? They've had significant impact on this case. And so the court does need to address that, because despite giving all benefits of the doubt, people kept on wanting to do it over and over and over again, including most recently on Friday, February 2nd. So that means the court has to address it. So if you give the benefit of the doubt after representations are made. So when do you want to hear it? please just give me a date, because I don't want to keep our jury out any longer, because you can appreciate the other parties want to do their closing arguments. We've got a lot of different people, we've got the jury waiting outside, we have to do a verdict form. Other things, it's just a schedule, you all knew, the court gave you advance notice I was gonna do it, so presumably you already talked about a particular date, right, among yourselves? So what date would you like?
Your Honor, is a Friday acceptable to you?
No, you knew we were gonna be dark on Friday for this
I'm
trial.
not this Friday, if you're looking
No, we cannot do it on the 15th.
on
Okay, here's what the court's gonna do. The court's did you all discuss a specific date that everyone's available?
We did not,
Okay.
we're open though, Your Honor.
Let's get you a date. Let's do the 14th. The 14th, okay, I'm gonna do the 14th at 1 o'clock,
14th at 1 o'clock.
okay?
Did that say where are you on?
February 14th at 1 PM, yes. Now, the other council need to be present. This issue is,
All council.
I said, no other counsel for plaintiffs and counsel for real water are not required to attend because the issue is not from counsel for real water or plaintiffs, to this court's knowledge, right? To this court's knowledge, the issue is solely the counsel of ETT / Terrible Herbst. I'm not precluding anyone from coming, you can bring who you want to bring, but to this court's knowledge, from the court's requirements, I have to hold a hearing with regards to the counsel that engaged in the conduct, which means I have to do it under, so that's who you all choose who you wish to be here, by whatever means. The court's not requiring it to be in person. The court's allowing you whatever method you all deem is appropriate with regards to the instant issue. Does that meet your needs, counsel?
It does, Your Honor, and just for clarification, you're envisioning, it sounds like it will be an evidentiary hearing.
I'm giving you all the opportunity to do what you deem is appropriate to address all of the outstanding issues, right? Because you all know the method by which you want to do it, or how you wish to do it. And at this juncture, I'm just setting you a time frame to give you the opportunity to do so. If you choose it, you do not want to have it as an evidentiary hearing, if you, okay, the court has certain information available to it. The fair thing to do, right, the appropriate thing to do, what the court said it was going to do, is give anybody who wants an opportunity to respond, so I have all the information available to me before I make a determination. The extent that you all, who you wish to bring, how you wish to provide it, etc., that I leave to ETT 1 DBA Terrible Herbst, okay? Because like I said, you all know who's involved in these decisions and the oversight, etc. This court doesn't.
Last question, I believe, Your Honor. I believe, as I'm standing here right now, that ETT would like the opportunity to submit in advance some sort of report or brief to, if for no other reason, outline what we believe is in play, so to say, but the infractions were, and that may expedite it. Does Your Honor have any objection if we submitted something in advance, and if no objection?
Well, the challenge with that is, as you can appreciate, is I don't know what date you're planning on doing it, by when, the extent, etc., right? So the court's not gonna take a position, whatever the rules provide, the rules provide. The court's not gonna take a position there, but realize what today's date is, and realize what you're going to present, okay? And so, like I said, it's your decision on how you wish to respond to this, because I was really hoping not to have to do this. That's why I kept on mentioning issues at bench, kept on saying things, and unfortunately, people did not want to comply. So I need to get on to the rest of my hearing. Thank you so much.
Thank you, Your Honor. Thank
Appreciate
you.
it. Thanks so much.
Apologize for consuming so much time this morning.
No worries, I just, as you can appreciate, in fairness, we got a jury waiting,
Yes.
verdict forms. I mean, this was purely scheduling, okay? I appreciate it. Thank you so much.
Thank you, Your Honor.
So, counsels, for purposes of the trial, the verdict form. Do we have an agreed upon verdict form, or is there something that the court needs to resolve?
Yes, Your Honor, Eric Pepperman for plaintiffs. We do have an agreed upon verdict form. I printed copies, but we incidentally printed a copy that still had the plaintiff's proposed on the caption, so we're correcting that now, and we'll print new copies for the court momentarily.
So you're saying it's agreed upon verdict form, is that correct?
Yes, Your Honor, and all the jury instructions are agreed upon, and we have copies of that for the court as well.
Okay, let's finish with the verdict form, and then I'll circle back to the jury instructions, okay? So counsel for Real Water, do you concur that there's agreed upon verdict form?
Good morning, Your Honor. Joel Odou for Real Water. We agree it's an agreed upon verdict form.
Okay, and this is a first form verdict form, is that correct? Because I have
Yes.
2 bench briefs, which, to my knowledge, I did not get any courtesy copies of, but,
We-
yeah, courtesy copies, huh?
Your Honor, Joel Odou for Real Water. We have exchanged courtesy copies. I think plaintiffs have brought theirs forward. We have ours for the court. We've exchanged it with plaintiff. It was our understanding when we broke on Friday that we will talk about the second phase after we get our business done with the jury today.
That's why I just needed clarification on the verdict form, when you said it was agreed upon verdict form.
The first phase only, Your Honor.
That's why I was trying to get the point of clarification, so that everyone's on the same page. Thank you so much.
Thank you, Your Honor, that is correct.
Okay, so now let's go to the jury instructions. Jury instructions, sorry, Mr. Pepperman, you're about to say with regards to the jury instructions?
All jury instructions are agreed upon as well, Your Honor. I have hard copies with all the numbering and the order for the court.
Sure. So is that the way that they are to be read to the jury, meaning it's got the correct caption, it's got all the page numbers, it's got all the language? Is that correct?
Yes, Your Honor.
And
that's
we're
correct.
also talking about phase 1, correct?
Yes, this is just the phase one.
Okay, no worries. Can you hand it to the marshal so we can get blue backed? And then counsel, what I'm gonna do is once Madam Clerk blue backs it, I'm gonna have Real Water take a quick look at it to make sure that that's your understanding. Can you hand it to staff? I just want to put blue back on it, so we, sorry, I'm gonna use the blue back portion. I appreciate it, thanks. So Marshall, can you hand this to counsel for Real Water and then?
Sure.
Counsel, just one thing,
Oh, that's
Jane.
the verdict. Okay, thank you.
So this is the jury instructions, so just, I had to put a blue back on it because I presume you all have a lot of things on your respective council's tables, so you might. And if it's, I'm asking you now because is anyone going to be utilizing jury instructions in your closing arguments? That's the reason why I'm asking you now. So we can make sure that you can utilize them, because if not, I'll wait till after. You're using them during the count? So you can just confirm, everyone can confirm that those are the jury instructions, so that you all can utilize what you need to utilize for purposes of your closing arguments.
Ready to proceed with the court's convenience.
Thank you. Are those the correct jury instructions? You agree?
Joel Odou for Real Water. Yes, Your Honor, these are the agreed upon jury instructions. I've inspected them and compared them to the electronic copies that we previously had.
Councilor Plaintiff, since you handed them, do you want to take a look at what you handed? I'm just making sure the blue back version is the one, because you know there's some more things floating around, so just make sure. And what did you all address with regards to the court recorder, so we're clear on that? Because the recorder versus reporter we went over, you're all gonna make yourselves available so that if there's a juror question that you're gonna be in very close proximity, go over anything that we would need to go with regards to the recording. So, I haven't seen it, so I don't know how you phrase it, that's why I'm asking.
Sorry, Your Honor?
Sure, with regards to the court reporter issue that was discussed last week, did you put in a court reporter, not a court reporter? Did you address the fact about having a agreed upon section of the testimony that would need to be read back?
The instruction. No, Your Honor, we did not get a different reporter.
Still says reporter?
Are you
So it
referring
doesn't
to?
say, I'm sure you understand the question. Do you remember on Friday we went over the fact that this department has a court recorder, not a court reporter? Remember going over the fact that a court reporter, there is no reading, right, a section if a juror has a question? I don't know if you kept in, because I haven't yet seen the jury instructions, if you kept in the jury instruction that has a court reporter and talks about readbacks, because you can't have, remember we talked about this on Friday, make sure, bless you, not to have the readback aspect because with a court recorder, you don't get any readbacks because it's not a court reporter, it is a court recorder. And you remember the court that went through the aspect that if you do include the court recorder instruction, that we need to ensure that counsel are present so that if the jury has a question, that you all have to listen with the court recorder to come up to the agreed upon time frame from a point, I think I probably said X and Y. It has to be played back to the jury when they come back in.
So we will be on standby for any readbacks, or I guess not readbacks, but
Does the jury instruction say reporter or recorder?
it doesn't say either. The jury instruction is number 27. It says, if during your deliberations you should desire to be further informed on any point of law or hear again portions of the testimony, you must reduce your request to writing signed by the foreperson. The officer will then return you to the court where the information sought will be given to you in the presence of the parties or their attorneys. Remember, the court is not at liberty to supplement the evidence.
Okay, so the way you all have done it is generic enough that it allows it to be a court recorder. It's not the one that says that there's going to be a readback and a court report. That's what I was just trying, that's the most common one that I get as an oops, and so since I haven't yet seen them, I didn't know it was done. So you all know the process, it's in there, and that meets your needs counsels for plaintiffs, is that correct?
Yes, Your Honor.
Does that meet your needs counsel for water?
Yes, Your Honor, it took us a minute to find it.
No worries, okay.
And Your Honor, these are correct. I just want to make one comment for the record. We originally proposed instructing the jury on the elements of the claims. Because of Real Water's admission of liability, they did not want to include those jury instructions. We don't disagree, but I just want to clear for the record that we agreed not to include the element instructions in the final proof.
Joel Odou for Real Water, that is correct.
Sure. So short version is what you're about to hand the court back, what's got the blue back on it is what you want the court to read, and everybody's agreeable that I read it as is that correct?
Yes, Your Honor, Eric Pepperman for plaintiffs.
Yes, Your Honor, Joel Odou for Real Water.
No, wait, that's what, just, like I said, we are in agreement, we're just need to intervene. Okay, do you have a verdict form, or is that still being printed?
I do have the verdict form, Your Honor. We don't have a staple.
Doesn't matter. My clerk can take care of that, it's not an issue. Is that the one you were able to change and take off the proposed stuff?
Yes, we
And
corrected
the
the
caption,
title.
can you show it to defense counsel before? That's it, thank you so much.
Joel Odou for Real Water, this is the correct verdict form.
Okay, Madam Clerk, then you can move back that. Okay. Any other matters that you want to address now? I understand you want the two briefs and the issue with regards to potential punitive damage instruction to be addressed at a later time today, but is there anything else that we need from the court at this juncture? Counsels for plaintiff?
No, no.
Counsels for defense?
Your Honor, Joel Odou for Real Water, are we ready to proceed with closing arguments?
Okay.
Instruction then.
Yeah, the instructions first, but yeah, okay. So I need the instructions back, thank you. Okay, so Marcia's gonna go get our jury. When they come back in, what we're going to explain to them, since everybody rested, that the next stage in the trial is the reading of the jury instructions, and then I will commence to read the jury instructions. Does that meet the needs of counsel for plaintiff? Yes. Or no? Okay, does that meet the needs of counsel for defense?
Joel Odou for Real Water, yes it does, Your Honor.
Oh, yes, sure. Oh, no, yes, of course. And the court's understanding by agreement, because this was confirmed last week, that even though the court granted the motion for good faith settlement and that Terrible Herbst is not going to be on the verdict form, you still wish them for ease to remain on the caption in the jury instructions and on the caption of the verdict form, correct, counsels, or is that incorrect?
Yes, Your Honor, that's correct.
Joel Odou for Real Water, yes, Your Honor, that is correct.
Okay, so what I see is I see instructions 1 through 28. Are these the totality of the instructions the parties wish the court to read to the jury?
Eric Pepperman for plaintiffs, yes, Your Honor.
Joel Odou for Roller, yes, they are, Your Honor.
Okay, thanks very much. Yes, Marshall, we're ready for our jury. Appreciate it. Thank you.
Okay, all rise for the jury.
Come on in, everybody.
Your Honor, all members of the jury are present. Everyone, please be seated.
Do appreciate it. Thank you so much. Welcome back, ladies and gentlemen. Hope everyone had a nice, relaxing evening. Sorry I can't control the weather. It was kind of a challenge. I know for everyone to get here. We do appreciate you being here this morning. So ladies and gentlemen, jury, if you recall on Friday, we had the resting of all the cases, right? Plaintiff's case, defense's case, and rebuttal case. And explained that the process, the next step in the process is for the court to read the jury instructions, okay? As you, the triers of fact, to determine the facts in the case, but the court review gives you the law for which you apply to those facts. So ladies and gentlemen, jury, I'm about to instruct you upon the law as it applies to this case. I would like to instruct you orally without reading to you. However, these instructions are of such importance that it's necessary for me to read them to you word for word. Please carefully listen to these written jury instructions, but do realize that a copy of the jury instructions will be with you at the time of deliberations in the jury deliberation, okay? The instructions are, some people might call them a little bit long. These aren't that long. And sometimes some may be lengthy on a particular instruction. I do read them one by one, and please do listen to each and every word. And please do keep it in mind that you will need to comply with the jury instructions when you go back to the deliberation room. And you'll be able to reread them as carefully at that time as well. So, instruction 1, members of the jury. It is now my duty as judge to instruct you on the law that applies to this case. It is your duty as jurors to follow these instructions and to apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict upon any other view of the law than given in these instructions to the court. Instruction 2. In these instructions and on the verdict form, defendants AffinityLifestyles.com Inc., a Nevada corporation, DBA Real Water, and Real Water Inc., a Delaware corporation, are collectively referred to as Real Water. 3. If in these instructions any rule, direction, or idea is repeated or stated in different ways, no emphasis thereon is intended by me, and none may be inferred by you. For that reason, you are not to single out any certain sentence or any individual point or instruction and ignore the others, but you are to consider all the instructions as a whole and regard each in light of all the others. The order in which the instructions are given has no significance as to their relative importance. 4. One or more of the parties in this case is a corporation. A corporation is entitled to the same fair and unprejudiced treatment as an individual would be under like circumstances, and you should decide the case with the same impartiality you would use in deciding a case between individuals. 5. The masculine form as used in these instructions, if applicable, is shown by the text of the instruction, and the evidence also applies to a female person or a corporation. 6. Although you are to consider only the evidence in this case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in light of common experience, keeping in mind that such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. 7. If, during this trial, I have said or done anything which has suggested to you that I am inclined to favor the claims or position of any party, you will not be influenced by any such suggestion. I have not expressed, nor intended to express, nor have I intended to intimate any opinion as to which witnesses are or are not worthy of belief, what facts are or are not established, or what inferences should be drawn from the evidence. If any expression of mine has seemed to indicate an opinion relating to any of these matters, I instruct you to disregard it. 8. You must decide all questions of fact in this case from the evidence received in this trial and not from any other source. You must not make any independent investigation of the facts or the law or consider or discuss facts as to which there is no evidence. This means, for example, that you must not on your own visit the scene, conduct experiments, or consult reference works for additional information. 9. The credibility or believability of a witness should be determined by his or her manner upon the stand, his or her relationship to the parties, his or her fears, motives, interests, or feelings, his or her opportunity to observe the matter to which he or she testified, the reasonableness of his or her statements, and the strength or weakness of his or her recollections. If you believe that a witness has lied about any material facts in the case, you may disregard the entire testimony of that witness, or any portion of this testimony which is not proved by other evidence. 10. In determining whether any proposition has been proved, you should consider all of the evidence bearing on the question without regard to which party produced it. 11. The evidence which you are to consider in this case consists of the testimony of the witnesses, the exhibits, and any facts admitted or agreed to by counsel. There are two types of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as testimony by a witness about what the witness personally saw or heard or did. Circumstantial evidence is the proof of one or more facts from which you can find another fact. The law makes no distinction between the weight to be given either direct or circumstantial evidence. Therefore, all of the evidence in the case, including the circumstantial evidence, should be considered by you in arriving at your verdict. Statements, arguments, and opinions of counsel are not evidence in the case. However, if the attorneys stipulate, meaning to agree, to the existence of a fact, you must accept the stipulation of evidence and regard that fact as proved. Questions are not evidence. Only the answer is evidence. You should consider a question only if it helps you understand the witness's answer. Do not assume that something is true just because a question suggests that it is. You must also disregard any evidence to which an objection was sustained by the court or any evidence order stricken by the court. Anything you may have seen or heard outside of the courtroom is not evidence and must also be disregarded. If the court has instructed you that you must accept a fact as proven or draw a particular inference, you must do so. If the court has instructed you regarding a presumption regarding evidence, then you must consider that presumption as well. 12. During the trial, you received deposition testimony that was read from a deposition transcript and or shown by video. A deposition is a testimony of a person taken before trial. At a deposition, a person took the same oath to tell the truth that would be taken in court and is questioned by the attorneys. You must consider the deposition testimony that was presented to you in the same way as you consider testimony given in court. 13. An attorney has a right to interview a witness for the purpose of learning what testimony the witness will give. The fact that the witness has talked to an attorney and told that attorney what he would testify to does not reflect adversely on the truth of the testimony of that witness. 14. Witnesses who have special knowledge, skill, experience, training, or education in a particular subject have testified to certain opinions. This type of witness is referred to as an expert witness. In determining what weight to give any opinions expressed by an expert witness, you should consider the qualifications and believability of the witness, the facts or materials upon which each opinion is based, and the reason for each opinion. An opinion is only as good as the facts and reasons on which it is based. If you find that any such fact has not been proved or has been disproved, you must consider that in determining the value of the opinion. Likewise, you must consider the strengths and weaknesses of the reasons on, let me redo that sentence one more time, please. Likewise, you must consider the strengths and weaknesses of the reason on which it is based. You must resolve any conflict in the testimony of the witnesses, weighing each of the opinions expressed against the others, taking into consideration the reasons given for the opinion, the facts relied on by the witness, their relative credibility, and their special knowledge, skill, experience, training, and education. 15. An expert witness has testified about their reliance upon books, treatises, articles, and or statements that may not have been admitted into evidence. Reference by the expert witness to this material is allowed so that the expert witness may tell you what they relied upon to form their opinions. Unless the books, treatises, articles, and or statements have otherwise been admitted as evidence, you may not consider the material as evidence in this case. Rather, you may only consider the material to determine what weight, if any, you will give to the expert's opinions. 16. The lawyers and witnesses have shown you charts and summaries to help explain the facts. The charts or summaries themselves, however, are not evidence or proof of any facts. Charts and summary are only as good as the underlying evidence that supports them. You should therefore give them only such weight as you think the underlying evidence deserves. 17. Plaintiff asserts claims for strict liability for a defective product. Real Water has admitted that the Real Water product that it manufactured was defective and unreasonably dangerous. Real Water has also admitted that its defective product caused injuries asserted by each plaintiff. Thus, the only issues remaining to be determined by you are: 1, the amount of compensation that should be awarded for each plaintiff's compensatory damages, and 2, whether Real Water is liable for punitive damages. 18, you must determine damages for each plaintiff. In determining the amount of damage suffered by each plaintiff, you will take into consideration the nature, extent, and duration of the injuries you believe from the evidence that each plaintiff has sustained, and you will decide upon a sum of money sufficient to reasonably and fairly compensate each plaintiff for the following items: the physical and mental pain, suffering, anguish, disability, and loss of enjoyment of life endured by each plaintiff from the date of his or her incident to the present. The physical and mental pain, suffering, anguish, disability, and loss of enjoyment of life which you believe that each plaintiff will be reasonably certain to experience in the future as a result of his or her injuries. The medical expenses which you believe that plaintiff Jasmine Schaefer, Tina Hartshorn, Christina Sosha, and Miriam Brody will each be the reasonably certain to incur in the future as a result of her injuries. The parties have stipulated that plaintiff Myles Hunwardsen future medical expenses are $900,000. The court has also already determined the past medical expenses for each plaintiff as a result of his or her injuries. Therefore, you should not include past medical expenses in your damages awards to each plaintiff, and you should not include future medical expenses in your damages award to Myles Hunwardsen. For plaintiff Myles Hunwardsen only, damages for loss of earnings from the date of the incident to present, if any, and the damages for loss of earnings or earning capacity which you believe you will be reasonably certain to experience in the future as a result of the injury sustained, if any. Also, for plaintiff Myles Hunwardsen only, damages for his shortened life expectancy. 19. No fixed standard exists for deciding the amount of pain and suffering damages, nor is the opinion of any witness required as to the amount of such reasonable compensation. You must use your judgment to decide upon a reasonable amount based on the evidence and your common sense. 20. Where a plaintiff's injury or disability is clear and readily observable, no expert testimony is required for an award of future pain, suffering, anguish, and disability. However, where an injury or disability is subjective and not demonstrable to others, expert testimony is necessary before a jury may award future damages. 21. According to the U.S. Department of Health and Human Services standard mortality tables, a 33-year-old male is expected to live another 44 years. This fact should be considered by you in arriving at the amount of damages to award plaintiff Myles Hunwardsen. This is the average life expectancy. Some people live longer and others die sooner. The published information is evidence of how long a person is likely to live, but is not conclusive evidence. In deciding a person's life expectancy, you should consider evidence, in this case related to that person's health, habits, activities, lifestyle, and occupation. 22. A party must persuade you by the evidence presented in court that what he or she is required to prove is more likely to be true than not true. This is referred to as the, quote, burden of proof, end quote. The plaintiffs have the burden of proving by a preponderance of the evidence all of the facts necessary to establish their damages. A, quote, preponderance of the evidence, end quote, means such evidence as when considered and weighed against that opposed to it, has more convincing force and produces in your mind a belief that what is sought to be proved is more probably true than not true. After weighing all of the evidence, if you cannot decide that something is more likely to be true than not true, you must conclude that the party did not prove it. You should consider all the evidence, no matter which party produced the evidence. 23. Whether any of these elements of damage have been proven by the evidence is for you to determine. Neither sympathy nor speculation is proper basis for determining damages. However, absolute certainty as the damages is not required. It is only required that each plaintiff prove each item of damage by a preponderance of the evidence. 24. You may consider whether you should award punitive or exemplary damages against Real Water. Punitive or exemplary damages are to make an example or punish wrongful conduct. You have discretion to award such damages only if you find by clear and convincing evidence that the defendants were guilty of oppression, fraud, or malice in the conduct providing your basis for liability. Quote, malice, end quote, means conduct which is intended to injure a person or despicable conduct which is engaged in with a conscious disregard of the rights or safety of others. Quote, oppression, end quote, means despicable conduct that subjects a person to cruel and unjust hardship with conscious disregard of the rights of that person. Quote, fraud, end quote, means an intentional misrepresentation, deception, or concealment of a material fact known to a defendant with the intent to injure or deprive a person of rights or property. Quote, conscious disregard, end quote, means knowledge of the probable harmful consequences of a wrongful act in a willful and deliberate failure to avoid these consequences. At this time, you are to decide only whether Real Water engaged in wrongful conduct warranting an award of punitive damages against it. If you decide an award of punitive damages is justified, you will later decide the amount of punitive damages to be awarded after you have heard additional evidence and instruction. 25. Clear and convincing evidence is that measure or degree of proof which will produce in your mind a firm belief or conviction as to the allegations sought to be established. It is an intermediate degree of proof, being more than a mere preponderance, but not to the extent of such certainty as is required to prove an issue beyond a reasonable doubt. Proof by clear and convincing evidence is proof which persuades you that the truth of the contentions is highly likely. 26. When you retire to consider your verdict, you must select one of your number to act as foreperson, who will preside over your deliberation and will be your spokesperson here in court. During your deliberations, you will have all the exhibits which were admitted into evidence, these written instructions, and a special verdict form which has been prepared for your convenience. In civil actions, 3/4 of the total number of jurors may find and return a verdict. This is a civil action. As soon as 6 or more of you have agreed upon each answer required by the directions in the special verdict form, you must have the verdict signed and dated by your foreperson and then return with it to this room. 27. If during your deliberations you should desire to be further informed on any point of law or hear again any portions of testimony, you must reduce your request to writing signed by the foreperson. The officer will then return you to court where the information sought will be given to you in the presence of the parties or their attorneys. Remember, the court is not at liberty to supplement evidence. 28. Now you will listen to the arguments of counsel who will endeavor to aid you to reach a proper verdict by refreshing in your minds the evidence and by showing the application thereof to the law. But whatever counsel may say, you will bear in mind that it is your duty to be governed in your deliberations by the evidence as you understand it and remember it to be, and by the law is given to you in these instructions, and return a verdict which, according to your reason and candid judgment, is just and proper. Dated February 5th, 2024, given District Court Judge Joanna Kishner. Thank you so very much, ladies and gentlemen. We've now read the jury instructions. The next step in the process is for the parties to engage in closing argument. Plaintiffs have an opportunity to go first. Counsel for plaintiff, whoever's doing their closing argument, feel free to commence with your closing argument.
Thank you, Your Honor.
And we need to remind anybody who's on remotely, please make sure you're on mute so we get a nice clear record of everyone. Thank you so very much.
My apologies, Your Honor, that was me. I was just making sure the audio worked.
No worries. Friendly reminder never hurts.
Good morning, ladies and gentlemen. This is the time for closing argument. So what's going to happen is I'm going to speak. Mr. Parker will probably give it up for about an hour. Mr. Parker's going to speak, probably a little less time. Mr. Odou is going to address his points, then we get a chance for rebuttal. Okay, then you get the case. Now to start, I want to thank you for being here. I know It's difficult to come here every day. Hopefully, this was a relatively interesting case. Hopefully it was judge made it a good experience for you, and we really appreciate you coming down here. Now, you heard jury instruction 17. There's 2 issues for you to decide at this point. 1, the amount of compensatory damages for the 5 plaintiffs, and 2, whether or not there's punitive damages. Let me start with punitive damages, okay? This is the verdict form, Jay. So this is the question you're going to be asked. Is Real Water liable for punitive damages? And the answer is either yes or no. We submit you should answer yes, and I'm going to talk about 4 different independent reasons why Real Water is liable for punitive damages. Shane? So this is their bad conduct. They did not do general, non-targeted screening tests that would have found the hydrazine before they started sales. Back at the beginning, back in 2008, they didn't do any testing whatsoever to see what there was in the product. In addition, after all these problems that we're going to talk about came up, they didn't do any general screening tests up until the recall in March. So they didn't do it at the beginning, and they didn't do it during the course of the product sales. That's problem number 1. 2, they had poor or non-existent quality assurance. Dr. Hutt talked to you about that. I can play back some of her testimony in a second. 3, they knew of serious customer complaints. We're going to play back some of the testimony. We're going to show some of the complaints. They did not diligently investigate them or review the manufacturing process. And I can play you the testimony of a couple people, Hutt, Desitel, others, that what they should have done. Next, they waited 5 months to start a recall, despite Mr. Randolph, the vice president of sales, meeting with Mr. Blaine Jones and begging on 2 different occasions to start a recall. So those are the 4 things that we think justify punitive damages. And let's go through them one at a time with more detail. Let me show you some of the testimony that you heard. Okay, this was a brand new water product. It wasn't just water, it was water that they added chemicals to, and then they added electricity to it. So it's not a bottled water with a tried and true manufacturing process. It was produced using these titanium tubes. Remember that picture, Shane? You saw the tubes. So they hung the tubes vertically, that's the tube holder. Then they injected the water through it, and they did this for a long period of time, 10 to 12 hours. I'm going to show you Mr. Marlowe's testimony in a second. And when they did that, Shane, they applied a constant electrical charge during the entire 10 to 12 hours. And so what happened? They made hydrazine. That's what happened. So there's 4 steps to this process, Shane. Juice it, mix it, and then they did some testing to see whether or not to add more concentrate. So we called John Marlowe. He was the inventor of the product, relatively old guy. He got up on the stand. And he admitted that there was a continuous electrical charge, not for 1 hour, not for 2 hours, but for 10 to 12 hours. Constant electrical charge on these tubes while they're putting water through it for 10 to 12 hours. Can I have Mr. Marlowe's testimony, Shane?
Okay, so if you're making, like 3 minutes a gallon, are you talking about the gallons going in or the gallons coming out? Or there's 3 minutes for each gallon to put in? Yes, I think that makes sense. You're right. Okay, so if we start with 300 gallons and it's 3 minutes a gallon, that would be 900 minutes or approximately 10 to 12 hours to do that first load. Is that right? That's how many gallons? 300 gallons? Let me start. That sounds approximate. That's all right.
Remember, they took the 300 gallons and they took out the acidic and the alkaline, and then That made to 150, and then they did it over again, and they wound up with 75 gallons. But the important point to remember is they applied this constant electrical charge during the entire time, 8 to 10 hours. That's how Dr. Frankenstein made his monster, okay? Constant electrical charge. And what was the result of that? The result is we had hydrazine in the product, and they didn't find it because Mr. Marlowe, he confessed on the stand. He told you he didn't do any testing. Here, well, let me show you what he said.
No, mass spectrometer, yes, I've heard of that. Okay. Did you do any testing on the product you developed using that? Not that I recall, no. Did you do anything that would tell you exactly what was in that water? No. And from the time point that you developed until, let's say, 2019, you know of anybody doing a test to see exactly what was in the water? No, I don't. No.
And we asked a similar question to Blaine Jones. Remember, he's the owner's son. He was the one who was making the concentrate. Mr. Parker asked him this question. We have the Shane.
And so from roughly 2008, when you began working there, until 2020, Real Water never tested for hydrazine, correct?
Not to my knowledge.
Now remember, there's two ways you can test for hydrazine. You can do the GCMS that tests for hundreds of things, including hydrazine, or you can do a hydrazine-specific test. They didn't do either. We're more focused on the general testing that they didn't do. So what was the result? Well, the FDA did testing when the problems arose, and the FDA did what Real Water should have done at the very beginning. They used this GCMS test. Let me show you Dr. Najim's testimony. And I've just put it up here frozen. This is the question and answer. This is what the FDA did. Remember, they went to the Real Water plant. They took 3 samples of concentrate. They tested them. They used this GCMS test, which is the gas chromatograph and the mass spectrometer. So it's a simple test. It's a simple test, okay? So it goes through, it doesn't just test for hydrazine, it tests for hundreds of toxins. So this is what they should have done at the very beginning. And when the FDA knew there was a problem, this is exactly what the FDA did. And how much would this testing, again, the GCMS testing, well, this is John Marlowe, okay? I mean, I think it's pretty self-evident that you should test your product before you sell it, especially when you're using this bizarre manufacturing process. But so we asked Mr. Marlowe if he agrees, should the water manufacturer know what's in his product before he sells the product? Can I play that, Shane?
And you would agree with me that a water manufacturer should know what's in his product before it sells it to the public?
Well, I assume that I did know, yes.
That you didn't do these tests, the mass spectrometry or the gas chromatograph?
No, I didn't.
So you assumed you know, but did you really know?
I guess I have to honestly say I probably didn't.
He's the inventor. He didn't know what was in this product. Real Water sold it for approximately, until the dates of these injuries, probably at least a decade. They didn't know what was in the product. They should have known what was in the product. And there's really no dispute that if you'd done the GCMS test, that they would have found what's in the product right away. Here's Dr. Najim's testimony again. And he's saying,
Someone like,
stop. He's telling you what the costs of these tests are. It's as little as $200 to $1,000. This is what they should have done at the beginning. They should have spent $200 to $1,000, figured out what they were selling when they were using this outlandish process to make the water. Go ahead, Shane.
someone like a bottled water company with Real Water wanted to send a sample to a lab to run through those GCMS instruments. Is that possible?
These are available functionality from commercial lab for the kids.
And as part of that testing, could Real Water have sent out samples of its water to test for a wide variety of different potential constituents in its product?
They certainly could have.
And do you know approximately how much the cost would be for testing like that?
It all depends on what you ask the lab to investigate and what you ask them to do. It could be a few hundreds, it could be a few thousands.
Hundreds or even $1,000 to figure out what's in your product. Okay? And like I said before, there is no dispute that this kind of testing would have found a hydrazine. Because here's what the FDA did. The FDA did these tests, the exact same ones I just talked about, the GCMS, see it right there up top, the 1.44, and they found the hydrazine concentrate. They found 3 different samples, 1.44, 1.75, and 1.33. They found it. And remember, hydrazine, okay, hydrazine is not a nice chemical, okay? Hydrazine is used to launch rockets. That's the primary use of hydrazine. So basically, we have a case where a bottled water manufacturer put rocket fuel in its product. And the problem with that is that hydrazine causes acute liver failure. And it caused the acute liver failure of these 5 plaintiffs. So let's summarize these testing facts. So the standard GCMS would have looked for hundreds of toxins. This is non-targeted. What that means is it's not just looking for one. It's not like a hydrazine-only test. It's just a test looking for anything, okay? They would have found it just like the FDA did. Next, 200 to 1,000 bucks, okay? And you don't have to use a special lab. Dr. Nasham discussed, there's hundreds of these labs across the United States. Most universities have them. Next, they didn't do it. They didn't do it before they started selling their product. Mr. Marlowe didn't do it. They didn't do it at any time afterwards. Next, Shane. And you heard Mr. Marlowe. He said they should have done it. I played that for you. The inventor said they should have done it, and it wasn't done. And so we think that that's why they're liable for punitive damages. Okay, so they're going to have a defense to this. And I think the defense they have is kind of a curveball. It's a misdirection play. So their defense is, oh yeah, we didn't do the GCMS, but we did bacteria tests every week or every quarter or whatever. So remember they showed you some bacteria tests done by someone called Silver State Laboratories? That is not a general screening test, okay? That is just a test looking for bacteria. And so I asked Mr. Marlowe if he understood the difference. Even Mr. Marlowe, who flunked chemistry in college, remember he said that? Even Mr. Marlowe knew the difference between a bacteria test and a screening test. Go ahead.
The bacteria test council just talked about, that's different than a wide ranging test to see what's in front. Right.
Okay, Shane, can I have my next slide, please? So here's the curveball, the misdirection. So they're going to stand up and say, oh. So here's the misconduct. They made the new product without doing any testing, didn't know what was in it. Here's what they're going to say. Here's what we say. They should have done the non-target screening. Here's what they're going to, and bacteria tests, they're not non-target screening tests. They're not intended to look for possible toxins. They can't look for possible toxins. You know, the FDA, when they wanted to figure out what was in the water, they didn't run bacteria tests, they did the GCMS. Next, Shane. And then they're going to talk about this Eurofin study, which found hydrazine in the retail bottles. That was a special hydrazine test. That's not what I'm talking about when I talk about general non-target screening tests. So the complete and total failure to do screening tests on a brand new water product, that's the first reason we think there should be punitive damages. Second, poor or non-existent quality assurance. We start out with Dr. Hutt, the quality assurance expert. This is what she said.
Hi, Dr. Hutt. When you studied your water, did you identify the problem areas in your operation?
I did.
Can you tell me what the problem areas were?
I think first and foremost, I found a complete lack of what I would recognize as a quality assurance program. They simply seem to hold no regard for having procedures. These are not voluntary, these are regulations. They're not just because these are good things for the industry to do. They are federal regulations that are required to have these quality procedures in place and the checks.
I don't think there's really any serious dispute that they didn't have good quality assurance or that they didn't care about quality assurance. And we start with the first quality assurance director. Remember Patty Converse? She told you herself that she had been the receptionist and they promoted her to quality assurance director, and this is what Dr. Hutt's testifying about next.
They did real water at times, someone that they called quality assurance director.
My reading from the depositions taught me that basically there are a number of people who were accountable for quality, and they were told they were quality control or quality assurance directors, but they didn't have any training. And they talked about the fact they didn't have any training in this job, they did not feel qualified. They were a receptionist who was moved into a quality director role, responsible for quality and delivery of safe water, with absolutely no training.
And this isn't disputed. We played you Patty Converse's testimony. You know, maybe she was a good receptionist. Maybe she tried hard to be a quality assurance director. Remember, she was the quality assurance director for 2.5 to 3 years. 2.5 to 3 years, they had a receptionist doing the quality assurance for this. Okay. This is what she said.
Now, when you got hired, you said you were hired to be the receptionist, and then a month later, you became the director of quality control. Okay. And I assume you've never been the director of quality control before?
No.
Who was the director of quality control at the time you were the receptionist?
There was nobody.
So they had nobody whatsoever before she took the position in 2014 approximately. And then she became the director of quality control without ever having held that position. Okay? So I asked her, you know, do you think you were up to the job? This is what she said.
And you would agree with me that if there was a water processing plant and you were director of quality control and there were things going on in some room that you had no access to, you could ensure the total integrity of the system?
Correct. I do know that. Now that you say that, I know it, but I didn't have that kind of background.
Okay. You didn't have the training to recognize that at the time.
Correct.
Admits herself she didn't have the training. Okay, but at least she understood that she was supposed to be the director of quality control. When she left, we got to Mr. Desatel, who was a fake director of quality control. They gave him the title. He's going to say that in a second. But he wasn't even the director of quality control. He was just a fake that they held out to satisfy people. Okay, so this is his testimony. They called him the director of quality control, but he wasn't really the director of quality control. He was working on production. Go ahead, Shane.
Did they reference you at any point as the director of quality control?
Yes, they did.
Did they tell you you were the director of quality control?
That was our title that they put my name to.
Were you the director of quality control?
No, I was not.
Did you prove the way that the real water operation was run?
No, I did not.
Why not?
Violations of good manufacturing practices, GMPs. I believe in cleanliness. You got to maintain the line. You have to obtain a certain level of standard to prevent, stuff happening to the product and thus getting to the customer.
Okay, so we start out with the receptionist, that's one of you in training, she's the director of quality control. Then we get to Mr. Destino, the fake director of quality control. This is an important position, okay? An important position. And, you know, it's not like they were complete fools that weren't told about this. They had this audit, 2018 from NSF, and they were explicitly told, okay? Shane, can I have that? No qualified individual should provide a level of competency necessary for production of clean and safe product. Note that the quality assurance director has resigned. That was Mr. Dessert, the fake one. So Mr. Odou is going to stand up and say, oh, we were just missing someone for a day. No, they were missing people for years before this. They had the fake one, and then they had the receptionist. So they were explicit. Shane, put that back up, please. Think about this for a minute, ladies and gentlemen. Quote, there was no qualified individual to provide a level of competency necessary for production of a clean and safe product. This is a bottled water company, and they didn't have anyone that could make a safe product. How more damning can it get, okay? And that's exactly what Dr. Hutt told you. She told you it was unprecedented. She'd never seen a finding like this before. Matt Shane?
The auditor wrote in her audit findings a most unprecedented remark I've never seen in an audit, and that is that there is no one qualified to competently make safe and clean water in this facility. No one qualified to make safe and clean water. That I've never seen anything like that in an audit report in my total experience. It is unprecedented to write such a thing that truly is incriminating in the sense of what she saw. Yeah.
Why is it important for a bottling manufacturing plant to have someone that knows how to make a clean and safe product?
Because people drink their product and it can make mistakes.
Remember, Mr. Odou is going to try to excuse this by saying, oh, the guy left the day before. That's not what happened. They had Mr. Destill, the fake quality control director. Before that, they had Congress. Okay, but this is important. For years this went on. Okay, that is the first reason we submit, or is that the second reason? Yeah, that's the second reason we submit that they should be liable for punitive damages. Third, the complaint procedure. Okay, when you make a product, you need a robust procedure to document, investigate, and address customer complaints. They didn't have that. Okay? This is Dr. Hutt again explaining why, or why you should have a customer complaint procedure, and why you shouldn't just send people water and not even. They didn't even send these complaints to the so-called quality assurance directors. Go ahead.
Right. They had basically no customer complaint system. They were receiving customer complaints, but the individuals who were delegated, without training, but delegated accountability for quality had no visibility to the customer complaints, so they couldn't see them and couldn't follow up on them. People at General Water were receiving them, but they did not follow any systematic process for understanding them, evaluating them, following up on them, trying to see if they had the real problems.
Okay, so who should have got the customer complaints? The quality assurance director. That's who should have got them. So let's go back to Mrs. Converse. We asked her if she saw the customer complaints.
First of all, I assume all the customer alert forms were filed in one big place, right?
I would think so. I never saw them.
Okay, you're the director of quality assurance.
Right.
Okay, the second problem is the way they were directed to respond to these complaints. We're going to show you some, because there were prior illnesses, there were even people in the hospital. So instead of investigating, instead of figuring out what's wrong with the plant or the product, their solution was send everybody free water. This is what Mrs. Converse said.
Okay, so when you received written complaints about your water causing someone an illness such as diarrhea, the solution was to send them free water.
Correct,
Okay, the solution was not to investigate as to whether there's a potential problem with the water.
correct.
Okay? In retrospect, do you think that was a good quality control procedure?
No, sir.
No investigation. Even she admits this was bad quality assurance procedure. And we had some very serious complaints, okay? We brought in Mr. Watkins. I don't know if you remember, he testified in stand. I can show you his testimony in a minute. He was in the hospital for a week in 2018. Go ahead, Shane.
Did there come a time when you went to the hospital? Yes. What time period was that? It was around May 2018. How long was you in the hospital? Over a week.
Okay, let's forget all the other bad stuff. You know, they didn't test at the outset, they didn't have quality assurance, they didn't investigate the complaints. This man was in the hospital for a week, and they knew about it because they sent an email. And this is June 20th, 2018. Quote, "My husband has been in the hospital for 2 weeks, and the doctor wants him to stop drinking alkaline water." He's in the hospital for, I said a week, it's 2 weeks, and the doctor connected it to real water. Okay, Dr. Hutt told you what they should have done, and I'm going to play it for you again. Go ahead, Shane.
It says, quote, "My husband..."
Excuse me, this is Michael Bush. This is one of the employees of Real Water. He was the production manager. He didn't know about this email, but he was the one, remember he worked at Nestle for a while? So this is what he said Nestle would have done if they'd gotten a complaint like this. Go ahead, Chief.
It says, quote, "My husband has been in the hospital for 2 weeks, and the doctor wants him to stop drinking alkaline water," unquote. Did I read that right?
Right.
Okay. Did you become aware at any time that a Real Water customer was in the hospital?
No, I didn't know about that. I mean, that sounds like a big thing. And say, for example, we're in Nestle and something happens like this, all management would shut the plant down just about 15 minutes or so and do a safety review it.
Right.
After I should report the military same kind of thing. But no, I don't remember that. No.
If Nestle got a report that one of their customers drank their water, was in the hospital for 2 weeks, they would shut the assembly line down, correct?
But they're just,
Dr. Hutt said it. This is what Nestle would have done. Let's go to Mr. Desitel again. Again, he's the first quality assurance director that wasn't told about the complaints. Next.
Okay, and what is it you should have done if you became aware that there was a serious problem? Stop production. And why would you have stopped production if you knew there was a serious problem?
Prevent further manufacturing of the water, to prevent any damage to anybody or the environment.
And did you ever stop production?
No, I did not.
Okay, and this is where it really gets bad. Because Mr. Desitel tells you why he didn't ever stop production. He was ordered by the owners to never stop production for any reason whatsoever. Mr. Desitel's testimony, Shane?
So someone put some limit on you to meet the manufacturing process?
Yes, they did.
And what type of limits?
The limits to where so far is not to stop production, to clean, to, meet basic cleanliness for a manufacturing facility. Because we are producing something that a human consumes.
And when you say limits, how were the limits given to you or imposed upon you?
I was called up to an office, sat down, and verbally told by Blaine and I don't remember her name, and basically said you will not shut down production for anything.
So Blaine Jones, the vice president of Real Water, told Mr. Desitel, quote, "You will not shut down production for anything." And it wasn't shut down despite Mr. Watkins being in the hospital for 2 weeks. There was no investigation. in addition to Mr. Watkins, there were serious complaints that should have been huge red flags for the exact same problem we're here for today, hydrogen in the water. Let's see, what is it, 54, Jim?
56.
Okay, so here's one they got in 2014. Chemical smell. Water with a chemical smell in it. You know, we know why now, because there's hydrogen in it, but they were told this in 2014. Nestle would have shut the line down. They didn't. Next one, Shane. This one, a gasoline-like substance in the water, a gasoline-like substance. Gee, I wonder what that was, you know? But again, they didn't, especially at this point, you would think they would have paid a couple $100 and done the GCMS test. You know, someone saying there's gasoline in their water. You need to know why. And Dr. Hutt told you that there should have been a serious investigation of these complaints. She told you that if there were complaints like this, the company should have started running this GCMS test. Listen to this testimony. She says this exactly. Go ahead.
Well, this particular complaint really did catch my attention for the reasons that we discussed earlier this morning, because this complaint identifies that the bottle was made on the same shift as the previous report, meaning the previous customer report made a few days prior. Now that's the key red flag, because now I have two complaints about the same lot, for the same shift, definitely the same lot, and that is a signal that something is very wrong. It was also similar, gasoline, white smell, a strong chemical smell. Those are all indicative of a true problem, and at that time, in my personal experience, we break down doors to find out what is going on with this particular manufacturing lot. There's definitely a problem, and that would be the response for any quality professional in any food industry or manufacturing and service.
Just breaking down doors, reviewing the professional.
Oh, yes, specifically, we go back to number one, the retained sample, and do a serious investigation using analytical chemistry to analyze what is in this block of water. You use gas chromatography, mass spectroscopy, HPLC, high pressure chromatograph, HPLC. We use all kinds of analytical tools in order to evaluate what is in that water. We go to the sample that we have on hand from that ship, from that lot, and do serious investigation.
So they could have done the GCMS at the beginning, which is what they should have done. They could have done it in 2014 when they got these complaints about gasoline-like substances. They definitely should have done it in 2018 when Mr. Watkins told him he was in the hospital for 2 weeks and the doctor said it was the water. Nothing done whatsoever. First GCMS test was the one that I told you about, run by the FDA. So those are the first three reasons, okay, that they're liable for punitive damages. Let's go to the fourth, the recall. They delayed the recall for 5 full months, despite the fact that the vice president of sales was in Blaine Jones' office begging, on his knees begging for a recall because he wanted to protect the public. The vice president of sales wanted to protect the public. So here's what happened. This is an exhibit. Let me see if I can find the exhibit number.
77.
77. Okay, so this is 77. So as of October 15th, so they were getting so many complaints from so many people here in Clark County that they took one guy and said, okay, you're the special complaint guy now. And that was this production manager, Anthony Brown. So they took all the complaints and he reached out to them, 25 to 30 calls. 12 to 15 of those customers canceled and were refunds, okay? But did they stop selling water? Did they tell the public? Did they start a product recall? No. Here's the testimony from Mr. Randolph.
So I went to Blaine and asked him and say, listen, I'm not trying to get into your business, but I know you were sick. Do you mind telling me what happened? And when he started explaining to me what happened, I'm like, dude, I got 2 people that got sick also. And I'm like, it has to be the water. I go, it has to be the water.
Remember Mr. Randolph, he was the one that was working with Shane Mosley. He bailed out before the Pacquiao fight, which is smart on his part. But anyway, so he went to Blaine Jones, and again, Blaine's the owner's son, the vice president of Real Water. He said he knew of 2 people at this time, the first time he went in. And you got sick, Blaine. You got sick. So Blaine Jones got sick. I'm going to show you that in a minute. He knows of 2 people that has sick. He's begging for a recall, and Blaine says no. Okay. Then he finds out, Mr. Randolph finds out yet another person that got sick. Okay. Yet another person that got sick, and went back 2 days later and said, we got to do a recall. And so Blaine says, oh, I did a bacteria test. This water's fine. Okay. I'm not going to do a recall. A bacteria test. Come on, really? He didn't do the GCMS that Dr. Hutt told us should have been done at the beginning, should have been done at investigating complaints. Go ahead.
Okay, so I said, you must do a recall. He said, well, he said, at first I thought it was the water as well, but then I went and did all these tests and everything was okay, so it couldn't be the water. And I'm like, well, yeah, but I know 3 people now who's been sick, and the only thing you guys have in common is that you drink the same water.
So here's Mr. Randolph. In October of 2020, coming up with the same conclusion that the Southern Nevada Health District, the CDC, and the FDA come up with 5 months later. All these people had one thing in common. They were drinking real water. Now, when you don't do a recall, there are 2 consequences. 2 consequences. One, you keep making money, okay? You keep selling your product. That's what they wanted, and that's what they got. But here's the second consequence. If you don't do a recall, the public is not informed, and more people get hurt, including people that are sitting over there. If you don't do a recall, people continue to get hurt. Go ahead, Shane.
So then I told him you need to do a recall. You need to get ahead of the game and do a recall. And he refused to do a recall. I went back to the office again. I learned of another person that got sick, and I went back to the office again. And once again, they just refused to. He said that they.
You talked to Mr. Jones again.
Yeah, he said that. Yeah, they said that he.
Yes, on a different date. Went back to.
Yes.
Okay. Okay. Remember the document I showed you, October 15th? That's what the day that they made Mr. Brown the special customer complaint guy. So on October 15th, that's the day the recall should have started. But there's no recall in October 2020. There's no recall in November 2020. There's no recall in December 2020. There's no recall in January 21. There's no recall in February 2021. It's not until March 21st, when the FDA and the CDC come to town and start the investigation. Only on March 21st is there a recall. So 5 months go by. And I told you there were consequences. So let's see what happened after October 15th. Shane? Christina, hospitalized on November 3rd. That's 19 days after October 15th. Tina, hospitalized on November 9th. That's, I'm not going to test me, that's 16 plus 9, that's 25 days after October 15th. Jasmine, hospitalized on November 15th, 2020. Okay, that's a month after they started getting all these customer complaints. This didn't have to happen. if they just told the public what was going on and be careful, don't buy our water, this didn't have to happen. But it did happen. And it did happen because they wanted to keep selling the water. They wanted to sweep the problem under the rug. And that's the fourth reason that we submit that there should be punitive damages. The box should be checked yes. Okay, now I'm going to turn to compensatory damages. And I've had a discussion with Myles, and I'm going to get into some detail about his injuries. And understandably, he just doesn't want to hear it. So I've asked him to leave. But no. Okay, compensatory damages. This is going to be the first thing you see on the verdict form. What are appropriate damages to compensate people? So let's kind of refresh our recollection of what happened to Myles. He went to Henderson Hospital. Go ahead, Jimmy. Goes to Henderson Hospital. They immediately realize that he's going to die. Okay? They immediately realize he's going to die, so they ship him to UCLA right away. Next. You saw this before. This is the flight for life. They throw him on the plane. They fly him to UCLA. Next, please. And when he got to UCLA, the UCLA transplant team took one look at his liver. Firm, stiff, pale yellow in color. I mean, had to have an operation in the, I think that's pronounced ascites there. His stomach was blown up with water that the liver couldn't process, so it had to go somewhere. So he's got an enlarged stomach. So they know they got a problem. Next. Here's the actual liver. Let's skip over that, Shane, because I'm going to want that one back in a second. So they do the transplant procedure. And these are all the steps. Dr. Hudson went through them with you in a lot of detail. I mean, this is an incredibly complicated medical operation, okay? And I don't need to go through them again. But, I mean, it spread out over the course of 2 days. They had some problems during it, but ultimately, Myles got a new liver. Next. So here he is. Now let's think about this for a minute. He walks into Henderson Hospital, stumbles in really, and the next thing he knows, he is waking up at UCLA on a ventilator with the tube done. I mean, 3 days later, he wakes up and he's on the ventilator. They tell him he's got a new liver, and look at this rack he's got. They've got to give him the anti-suppression drugs. They've got to give him IVs for other reasons. There's devices on the bottom for waste. Just amazing. Next. So this is his testimony about, he called it the Christmas tree rack, okay, which I think is kind of an innocuous way of saying it, but let's hear what he says about it.
That's with the rack.
Well, you have to have the Christmas tree with you if you go anywhere, so yes, I have the rack with me, that was whoever, and in the ICU, you have a designated nurse that checks on you every hour, on the hour, if they're not in the room with you the whole time, so I had someone to drag my tree around, no problem.
Well, he thinks it was no problem. I think it was a big problem that you have to give this guy anti-rejection drugs for the rest of his life. Let's start talking about those. So, anti-rejection drugs, immunosuppressants, you heard their names, mycophenolate, and the other one I just called TAC, okay? For the rest of his life, okay? He can't stop taking them now. He can't stop taking them 5 years from now. For the rest of whatever life he has to take these anti-rejection drugs. And why? He doesn't have the liver that God gave him anymore. He's got a stranger's liver that the body's trying to attack constantly. And if that strange liver is attacked and injured, Myles dies. Okay? So that's why he's got to take these anti-rejection drugs. Next shape. And these are powerful, powerful medications. Because think about it for a minute. They are basically disabling your immune system. Powerful medications. So the UCLA team, we talked about a little bit. His coordinator's name is Alice, I think Lee. Constantly he's having to get tested. They check the TAC level. They just calibrate. This is not a one-stop and you're out kind of thing. This is for the rest of his life that we're going to have to monitor. Next, Shane. And there's problems from these anti-rejection drugs. More probable than not that he's going to get skin cancer. I'm going to play Dr. Hudson's testimony in a minute. More probable than not that he's going to get diabetes. More probable than not that he's going to get prostate cancer. It hasn't happened yet. Hasn't happened in the first 5 years, but it's going to happen. All right, next, Shane. Oh, and the skin the skin cancer. Because of that, he's got to be inspected on a regular basis. Inspected is probably a nice word, but this is not a comfortable thing for a man to have to go through. Shane?
So I got the bone one, and the skin one was like right in the same area, so I did that one too. And when they did the skin one, it was a lady and 3 other people were in there, but she has me stripped down. And then after I'm already naked, she asked me if it's okay if they say that they're students, and I remember thinking, what? It's a little late to ask now, but I'm like, yeah, it's fine. So I have to turn around, and I think I had my hands covered in my private, because it was some ladies and dude, and it just, I just felt, I'm not that shy, but in that setting, turns out I'm shy, and so she's like, don't cover nothing, blah, blah, so I did a turn, and then I got dressed, and that was it, but it wasn't a good experience, I haven't gone back.
So for the rest of his life, he's going to do this because they know there's going to be skin cancer. They want to catch it right away, okay? So that's why they're going through this procedure. So these are the diseases that are caused by the anti-rejection drugs. Skin cancer, we just talked about. Hypertension, that's high blood pressure. Diabetes, next. Cardiac problems, which is caused primarily by the high blood pressure. And colon cancer, okay? This is Dr. Hudson's testimony going through all these diseases. And remember, he's saying that it's more probable than not that Myles is going to have this. Not now, but sometime in the future, he's going to have each one of these diseases. Next, please.
So reasonably, more probable than not, reasonably better probability. Now I just go through the list and you study hypertension.
Yes, sir.
Diabetes.
Yes, sir.
Dyslipidemia.
Yes, sir.
Can you tell us what that is again?
That's an increase in cholesterol and triglycerides in the body.
Impairment of the renal function.
Yes, sir.
Cardiovascular morbidity and mortality.
Yes, sir.
You may subject them to colon cancer.
Yes,
sir. All of these as a result of consuming the
yes, sir.
and then, of course, having to take the immunosuppressants related to keeping himself alive.
That's correct.
And you said he will have to take these medications for the rest of his life.
That's correct.
Okay, another problem, the bone density. When you take the anti-rejection drugs, your bone density deteriorates. So instead of having the bone density of someone in their 20s, 30s, 40s, you get the bone density of an old person. Your bones become more brittle. And because of that, there's going to come a time when Myles has to give up doing the things he loves, outdoor activity. He'll have to get off the dirt bikes. He'll have to stay in the house, because, you see older people, 70 or 80, they've got to be extremely careful. And that's where he's headed. All right, next, Shane. Oh, this is the kidney problems. I think I missed that. Shane, go ahead. The tacrolimus, that's one of the anti-rejection drugs. That's the other one, mycophenolate and tacrolimus. Go ahead.
Does tacrolimus also affect your renal or kidneys? The renal system or your kidneys?
Yes, sir. It has a direct toxic effect on the kidneys.
Okay. So those are all serious problems. But there is a bigger problem here. All right? These drugs, which you have to take twice a day for the rest of your life, the mycophenolate, the tacrolimus, cause birth defects. So if Myles were to have children, this is the warning that they actually give with the mycophenolate. If you are married, or if you have someone that you're having sexual relations with, and you're on mycophenolate, they advise you to be on contraceptives because they don't want this risk of birth defects. Okay, go ahead, Shane. So this has had an effect on Myles. I think it's understandable. I mean, you know, this kid has a lot to process. A lot to process, all right? Go ahead, Jim.
It's birth defects, and I haven't really had a girlfriend since this whole incident. I just, I don't know, it's just overwhelming, I suppose.
Because of the condition, because of potential problems,
Well, yeah, the birth defects, you know, what if I do find the woman of my dreams and I get married and now it's time to have kids and you know, I don't know, it's just scary to think about. I haven't really processed it, I haven't really thought about it.
And before this, he told you that his dream was to get married and have children. Before 2019, that was his dream. That was his plan. He was looking for, I think, what he called it, the perfect woman. That dream is now shattered. That is gone. Okay, I'm going to get into the loss of life expectancy in a second, but I want you to remember that at the end, the last 2 or 3 years of Myles' life, it's no picnic. It is not going to be a picnic because I've already told you about the deterioration of the bone. I've told you about all these other potential problems. The last 3 years of his life, 2 years he's going to have, maybe 3, home health care. In that last 6 months, he's going to be in a hospice because he won't be able to care for himself the last 3 years. And how do you know that? Because Dr. Hudson told you so. Go ahead.
And is it also fair to say that because Mr. Hunwardsen's liver transplant unfortunately makes him susceptible to all of the side effects we discussed earlier, that in his later life he's going to need hospice care at home?
Yes, sir, that's my opinion.
And is it your opinion that he will need help, either through hospice or home care, just to manage his last 7 years?
Yes.
Now, all those problems, and now we're going to talk about the big problem. This is the biggest problem. I called it during the opening statement, the stolen years. He's born in 1990. You heard the life expectancy is 77 years for him as a 33-year-old man. So 1990 to 77, we just added it there, so that comes out to be 2067. So Dr. Alsina, he's the transplant specialist for the defense. Didn't appear to testify, but that's who he is. So he says that Myles is going to live 20 years after the transplant. So he's got the end of life for Myles in 2039, roughly. Dr. Hudson's more optimistic, okay? Dr. Hudson gives him 30 years. So 30 years after transplants, 2049. So I think what we should do is, and I put an arrow there, let's just split the difference between them. Let's, because no one knows for sure. Even the judge's crystal ball can't tell us, right? But so 2030, let's just say it's 25 years after the liver transplant, right? If it's 25 years after the liver transplant, we're talking 25 onto 19, so that's 2044. That's the expected date of death for Mr. Hunwardsen, 2044, okay? So he's got 23 years that have been stolen from him. 23 years, all right? 2044, that's 20 years from now. So 20 years from now, again, this is the middle ground between the two experts. 20 years from now, Mr. Hunwardsen is going to die. In the last 3 years, he's going to be confined to the home care and the hospice. So that is the big the big damages question in the case. And I want to show you the testimony about the Dr. Alsina and Dr. Hudson's, the 20 and 30 years, just so you don't, so you know I'm not just saying something. This is actual testimony. Go ahead, Shane.
Based upon Dr. Alsina's deposition transcript, is he predicting somewhere around 19 years, 20 years? You're hopeful that, that Mr. Hunwardsen maybe will last longer, maybe even 29 or 30 years?
Yes, sir. So I'm just splitting the difference at 25, all right? And 25 results in 23 stolen years. Okay, 23, that's Michael Jordan's number. Lucky for Michael Jordan, lucky number for him. Not so lucky for Myles, okay? 23 years of lost life. And like I've already said, the last 3 years, not so great. So these are the damages elements. You've got the liver transplant. It happened in the past, but it's a permanent injury. He's never going to get his liver back. Next. The anti-rejection drugs, that's in the past and future. And the reason I'm trying to break down past and future for you is when we go to the verdict form, you'll see that the first item is past. In other words, damages prior to today. And then the second thing is future, damages for future. Okay, so that's why I'm trying to break this down for you. Has to take the anti-rejection drugs. He's taken them for 5 years. He's got to take the rest of his life. Next. The monitoring, he's done that for 5 years. Has to do that for the rest of his life. Next. This is future, the skin cancer. Next, Shane. High blood pressure, future. Bone density, future. Next. Renal, kidney problems, future. The birth defects, that's in the future, that hasn't happened yet. The lost lifespan, that's going to happen in the future, like I said, 2044. So here's the verdict form. Okay, this is the form that you're going to have to fill out. Can you make that a little bigger, Shane? Okay, so remember I told you past and future. So you got to do the past, the last 5 years from the operation on September 19, 2019 to the present day. And then you got to do the future. So you've got to look at the past, put a number on the past permanent injury, the future permanent injury, the past physical and mental pain, suffering, loss of enjoyment of life, the future loss of enjoyment of life, the past lost earnings and loss of earnings. We actually have some numbers from an exhibit for you. And then the big one, the loss of life expectancy. All right. So let's start with the past physical and mental pain, suffering, anguish, permanent injury, and loss of enjoyment of life. Shane, can I have the liver slide back up? The other one? Okay. This is the primary past injury. He does not have his own liver. And think how this happened. He stumbles into the hospital. 3 days later, he wakes up at UCLA on a ventilator. This wasn't a planned operation. This was acute liver failure that had to be addressed immediately. But this liver has been taken out of Myles. This is his actual liver from the medical records. Taken out of Myles. They slice it in half. Dr. Hudson told you they wanted to analyze a little bit. He'll never have this back. This is a past permanent injury that he'll never get back. All right? It's a future injury too, but it's a past injury. And this is why they had to put the stranger's liver in. So in the past, we have him losing one of the most important, if not the most important organ in the body. You know, you've got the heart, the brain, the liver. Those are pretty much the big three. That's gone. That is gone. So you're going to have to put a damages element on that. And why was this liver destroyed? It was riddled with rocket fuel. That's why the liver was destroyed, because he drank renal water that had rocket fuel in it. All right? And then we have The other things I've already talked about, the anti-rejection drugs, the monitoring you just had to go through. I mean, so the first question is, what is it worth? What is it worth to lose your liver and have a stranger's liver? What is that worth? Okay? What is it worth for the 5 years that he's had to go through? All right? What is that worth? All right? And there's no magic formula here. There's no table that I can hand you and say, oh, here we go, slot him in, check, check, check. You know, it's subjective. There's some subjective things, but this is up to you. This is your first big decision in the case. And so we're going to suggest to you the number of 20 million. Go ahead, Shane. So that's for the 5 years and the lost liver. Next, we have the future. Let's leave the number off when we talk about Shane. We have the future physical and mental pain, suffering, permanent injury. Remember, he's not getting his liver back. He's got this stranger's liver forever. And there's a time element here that's greater than the first, okay? The first has only been for 5 years. Now we're going from today, 2024, to 2044. This is going to be the next 20 years, okay? So that's why I think this should be a bigger number. And again, this is subjective. This is your decision. We think it should be 30 million. Past loss earnings, there's an exhibit. The exhibit, go ahead, Shane, put the number in. Those are his lost earnings. Future lost earnings. That's in the exhibit. It's exhibit, let's see, what did you do? Sometimes I get off script, ladies and gentlemen. I think it's 300. I'm not absolutely positive. 381? 381. Okay, 381. Thank you, Mr. Brown. All right. So now we go to the big one, loss of life expectancy. What's that worth, losing 23 years of your life? Is it worth $2 million a year? Is it worth $3 million a year? I mean, it's subjective, okay? But that's the decision that needs to be made. And before you make this decision, I want to show you what his life would have been if he'd kept his original liver and what it's gonna be because he doesn't have the original liver. Shane? 2044, this is the time period he's going to die. He would have been going to holidays with family next year. 2045, he would have been alive next. 2046, next. Birthdays, he's going to miss. Halloween's he's going to miss. Valentine's Day, he's going to miss. New Year's, he's going to miss. Easter, he's going to miss. Because that is when he's going to die, 2024. So all this is going to be missed. And what's going to, I think Shane's got 23 of these, one for each year. And you got to think about it. You can't just say, oh, it's only 23 years. It is a whole year of life. Each year for 23 years. And you know what you can do in a year because everyone does it, you know. They enjoy holidays, they enjoy it with their family. Now Myles can't do it, right? So, obviously he would have stayed young if he hadn't had this illness, but so that would have been his life expectancy, 2067, if we hadn't had this injury. And now what's going to happen? Do you know what's going to happen now, Shane? He's not going to be here. He's not going to enjoy any of those things. No more time with family. No more time with friends. Can't pursue whatever makes him happy. No more holidays. He's not gonna be here. He's gonna die in 2044. And that is the decision, the big decision I think you have to make. Only the good die young. Only the good die young. And it's up to you to find appropriate compensation. And we would suggest, I could say 3 million a year, I could say 4. We would suggest 2. 2 times 23 is 46. Beginning of the case, Mr. Parker told you this was a big case. It is a big case. All right, that's Myles' damages. Let me move on to Jasmine and Tina and Mrs. Brody.